Hello, I'm David R. Schneider, estate planning attorney, and I'd like to welcome you back to our series of videos on estate planning basics. This video is going to talk about who needs to have an estate plan, what the tax consequences can be of an estate plan, when you should get started on your plan, and why you should get started on your plan. Another common question that I'm often asked is, when do I need to create my living trust? Do I do that when I'm older? Do I do that when I am ready to retire? Do I wait until I have children, or I wait till I have a home? Well, my answer often surprises people. But when somebody asks me, when do I need to create my living trust, I always ask them, when are they going to die? I don't know the answer to the question. Most people need to have a living trust once they've started to develop assets or take on a more mature role in this life. When you buy your home, when you say I do, when you have children. Obviously, the majority of us should pass away in our senior years and not in our younger years. But reality is what reality is, and we don't really know when that time is going to come. The time to create your plan is now. The time to create your plan is while you are in the here and the now and the knowing, and can use your right mind to set out the terms and the rules that you want your estate to be governed by. A second question that I'm asked with some frequency: how hard is it to operate the living trust? What will happen when my property is titled to the trust? Do I have to do lots of paperwork? Am I having to do extra tax returns? Do I have to hire an accountant? Well, it's actually amazingly simple. First, when we talk about the operation of the living trust, once the assets are titled to the trust, as an example, your home, there's nothing else to do. You still pay your home mortgage the way you normally would. You still deduct the mortgage interest and property taxes off of your income taxes. You still can choose to refinance your home, get a HELOC or equity line on your home. There's no change from your normal day-to-day life. The trust does not prepare its own tax return. It is a revocable trust. So all your tax returns, your California return, your federal return, all remain the same. There's no extra work that's involved. The total work is in the creation of the trust and what's called funding the trust. Funding is taking the assets and titling them into the name of the trust. So when you come and you work with the attorney and you develop this big, expensive looking, nice leather-bound book, if you will, that's half the battle. That's the first job. The second job is funding the trust, taking title to the assets and retitling them in the name of the trust. As the attorney, I always help my clients with transferring real estate into the trust. This can be a little bit more complicated, and having helped families, over 3,000 families over the course of my 19 years, I am skilled at transferring the property without having any ill effects on you or any increase in your property taxes. When it comes time to transfer your other assets to the trust, I instruct you how to do that work. I cannot speak to Bank of America or to Morgan Stanley on your behalf. I have to teach you how to do these things. The third question that I receive with a lot of frequency: what assets do I have to title into the name of my trust? If I put my house in the name of the trust, do I have to change my bank accounts or my brokerage accounts? My answer is that you want to transfer as much of your assets into the name of the trust as possible. This means checking, savings, CD, money market, brokerage accounts. You want to retitle life insurance into the name of the trust. You may wish to consider naming the trust as beneficiary of your retirement plans. Every family presents a different set of facts which might produce a unique answer to that family. Assets are broken into three primary categories. Non-qualified assets, which are things that you've already paid income tax on, life insurance, and tax qualified assets, things you have not yet paid income tax on. All non-qualified assets, checking, savings, CD, money market, brokerage accounts, should be titled in the name of the trust. We do not consider how large or small the account is because these things fluctuate over the course of time. Somebody might say, my checking account never has more than a couple of $1,000s in it. Well, that's probably mostly true until the time that it doesn't. Perhaps you've sold your home and are purchasing another home, but the escrows are not simultaneous, and you have to park the money in your checking account for 1 day, 3 days, 5 days a week. Well, if all that money is in that account and you pass away, now we have problems when they're not part of the trust estate. So our recommendation is to transfer title, change title of all non-qualified assets into the name of the trust. When it comes to life insurance, we want all life insurance to pay to the trust. We want those assets to be there for the benefit of our surviving spouse or our children, and we want them to be there and readily available and under control for the benefit of the beneficiaries. When it comes to the third category, tax qualified assets, our federal government does not allow tax qualified assets to be retitled in the name of the trust. What is a tax qualified asset? IRA, 401k, 403b, anything that is tax deferred. Those assets must be owned by a human, not humans plural, humans singular. Now, all of those assets have something called a beneficiary designation. That means that when the account holder passes away, the beneficiary inherits the money by operation of contract, the contract in establishing the IRA or the 401k. The question becomes, what about successor beneficiaries? If, as an example, we're talking to a young family, husband and wife, and they have 2 or 3 children, and the children's ages are 15 to 9, we don't want those children to inherit the IRA or the 401k money until they are more mature. So now we can utilize the living trust as a beneficiary for those assets. Another question that I'm frequently asked about is, what do I have to be worth to create a living trust estate plan? Isn't that just a tool for rich people? No, as we've shown through an earlier segment when we talked about probate proceedings, it takes as little as $50,000 in real estate or $100,000 in personal property to trigger the necessity of the probate proceeding. So clearly, this is not a tool of the rich, but actually really a tool of the everyday man. Most people that live in Southern California are going to clip these totals, these very low thresholds, and thus utilizing the living trust really becomes mandatory. Another group of people will often talk about costs. The costs of developing a living trust plan differ or vary from provider to provider. We work with clients to make sure that our product not only meets all their needs, answers all their questions, and develops and delivers a plan that those persons, the client, understands, but it is affordable as well. Another question that's often posed to me is, hey, isn't this something I need if I'm going to pay exorbitant taxes, or if I have a large what's called estate tax or death tax or inheritance tax? The Revocable Living Trust has the ability to minimize, or for many families, eliminate the federal estate tax. For all of these reasons, people need to develop their estate plan at an early age rather than waiting for the inevitable or trying to now jam a plan together when they are sick or on the verge of becoming disabled. If you would like more information about this topic or any of the topics in our series of videos, or to book a free no-obligation consultation with me, please give our office a call. David R. Schneider, 805-374-8777. Or please visit our website at drs-law.com.